Let us now discuss an important concept: partnership with a minor, under Section 30 of the Indian Partnership Act, 1932. The question may be asked from this topic: can a minor be admitted to the benefits of partnership? If yes, what are the rights and liabilities of such a minor after attaining majority? By virtue of Section 10 and 11 of Indian Contract Act 1872, a minor is not considered capable of giving consent, and thus any contract with a minor is void ab initio. Therefore, a contract of partnership with a minor is also void. Because as per Section 5 of Partnership Act, the relation of partnership arisen from contract, not from status. In other words, a partnership cannot be done with a minor, and a minor cannot become a partner of a firm. However, a minor can be admitted to the benefits of the partnership as per Section 30 subclause 1 by the consent of all the partners. As per Section 30 subclause 1, a person who is a minor according to the law to which he is subject may not be a partner in a firm, but, with the consent of all the partners for the time being, he may be admitted to the benefits of partnership. This means that unanimous consent is essential. Even if one partner does not agree, the minor cannot be admitted. Thus, admission of a minor is not automatic. It depends entirely on the willingness of all existing partners. This provision ensures that every partner has a say in deciding whether a minor should be associated with the firm. Such minor has a right to share of the property, right to share of profits of the firm, right to access to and inspect of records, right to copy any of the accounts of the firm. These rights enable the minor to stay informed about the financial position of the business, even though he does not participate in its management. The liability of a minor is limited. Only his share in the property of the firm is liable for the acts of the firm. This means that if the firm incurs any losses or liabilities, they can be satisfied out of the minor's share in the firm, but not from his personal assets. In other words, the minor is not personally liable for the debts or obligations of the partnership. Second, a minor does not have the right to sue the partners for accounts of a payment of his share while he continues in the firm. However, there is an exception. When the minor decides to sever his connection with the firm, he can then sue the partners for his share of the property and profits. In such a case, the value of his share will be determined according to the principles laid down in Section 48 of the Indian Partnership Act. Thus, the law protects the minor by limiting his liability, while also providing a remedy when he chooses to exit the firm. Liability of minor after attaining majority, at any time within 6 months of his attaining majority, or of his obtaining knowledge that he had been admitted to the benefits of partnership, whichever date is later, such person may give public notice that he has elected to become or that he has elected not to become a partner in the firm, and such notice shall determine his position as regards the firm, provided that, if he fails to give such notice, he shall become a partner in the firm on the expiry of the said 6 months. In other words, within 6 months of attaining majority, or of becoming aware that he was admitted to the benefits of partnership. Whichever is later, he must decide his status in the firm. He has 2 options: either to become a partner, or to not become a partner. To communicate his decision, he must give a public notice. This notice is very important, as it determines his legal position in relation to the firm. Now, what happens if he fails to give such notice? If no public notice is given within the prescribed 6 months, the law assumes that he has chosen to become a partner. In such a case, he automatically becomes a full partner in the firm after the expiry of 6 months, with all rights and unlimited liabilities. Thus, the law provides a reasonable opportunity for the minor to make an informed decision, while also ensuring certainty for the firm and third parties. Now, let us understand an important procedural aspect: the burden of proof. Where a minor has been admitted to the benefits of a partnership firm, and after attaining the age of majority, he has not opted that whether he will be a part of partnership firm or not, and 6 months expired, and not that person is claiming that he had no knowledge of admission of partnership firm. In this case, that person has to prove the lacking of knowledge. This provision ensures fairness and prevents false claims regarding ignorance, especially after the expiry of 6 months from attaining majority. Now, let us understand the situation. When a minor, after attaining majority, chooses to become a partner in the firm, once he elects to become a partner, certain legal consequences follow. First, his rights and liabilities as a minor continue up to the date on which he formally becomes a partner. However, from that point onward, he becomes personally liable to third parties for all the acts of the firm, even those acts which were done since he was admitted to the benefits of partnership. This means his liability becomes retrospective in nature. Second, his share in the property and profits of the firm remains the same as it was during his minority. In other words, his profit-sharing ratio does not change unless a new agreement is made. Thus, by choosing to become a partner, he accepts full rights and unlimited personal liability, along with continuity of his earlier share. Now, let us understand the position. When a minor, after attaining majority, chooses not to become a partner in the firm, in such a case, the law provides the following consequences. First, his rights and liabilities will continue to be those of a minor up to the date on which he gives public notice. This means he remains protected from personal liability until that point. Second, after the date of public notice, his share in the firm will not be liable for any acts of the firm done thereafter. In other words, he is completely free from future liabilities of the firm. Third, he becomes entitled to sue the partners for his share of the property and profits of the firm. Such determination is made in accordance with the provisions of the Act. Thus, by choosing not to become a partner, he safely exits the firm without incurring personal liability, while still retaining his right to claim his due share. Let us now revise the rights and liabilities of a minor admitted to the benefits of partnership. A minor enjoys the following rights. First, he has the right to such share in the property and profits of the firm as may be agreed upon by the partners. Second, he has the right to access, inspect, and copy the accounts and records of the firm, ensuring transparency in business dealings. Third, his share in the firm is liable for the acts of the firm, but he is not personally liable. This means his personal assets remain protected. Fourth, he has the right to sue the partners for his share of profits and property, but only when he decides to sever his connection with the firm. Fifth, under Section 30, subsection 5, he has the right of election after attaining majority, within 6 months of becoming a major, or of gaining knowledge of his admission, whichever is later. He must give a public notice, stating whether he chooses to become a partner or not. If he fails to give such notice within the prescribed time, he will be deemed to have become a partner automatically after the expiry of 6 months.